All right. Yeah, you're going to get 5 questions out of this chapter. Now, y'all, I'm going to tell you, this is not a big chapter. Doesn't appear to be a lot of information, but for me, that's a lot of questions given this chapter. So obviously, do you think as a real estate agent, you should know what and by the way, what does mandated disclosures mean to you?
You have to tell them.
There you go. And when you tell them, how do you have to tell them?
In writing.
In writing. Very good. Just want to make sure y'all everything we do has to be in writing. Y'all, I'm telling you, you get audited or inspected, they're not going to buy into this. But I told them, no, you didn't. Not if it's not in writing, you didn't. So just beware. Okay. Well, y'all, the first thing we look at is this. It's called the South Carolina Property Condition Disclosure Law. And what you're actually looking at in your book, now, obviously I don't have this on the PowerPoint slide, but in your book, it's a 5-page document. It's a form. You know, it's called the Property Condition Disclosure Form. Everybody see that? It's 5 pages long. But if you're on the first page of this form, y'all, this is what we got to look at here for a little bit. In fact, I refer to this first page as like the instructions page. And basically, y'all, in a nutshell, here's what this requires, this law. If you're selling your home, does the law require the seller to disclose in writing everything they know is wrong with the house or the property?
Yes.
Yes. Y'all, that's the point of the law, and it has to be in writing. Well, y'all, if you look at the very first sentence on this form, I see at least 2 questions that they will likely ask you in that first sentence. So let's take a look. Y'all, it says the South Carolina Code of Laws, yada, 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 requires that an owner of residential real property, which includes single family dwelling unit or a single transaction involving transfer of 4 dwelling units or less. I'm going to stop right there. What kind of properties are required to provide this property disclosure form?
Residential real.
Residential property that has 1 house, 1 dwelling unit, or up to 4 units, you know, like a quadruplex. So if you're selling a single family home, duplex, triplex, or quadruplex, this form is required. There's the first question. So you know when this is required on what properties. But here's the next question, or next thing. It says, shall provide to a purchaser this completed and signed disclosure statement prior to forming a real estate contract. Y'all, when must the seller fill out this form and provide it to the buyer? By what point?
Prior to forming the real estate contract.
I remember that. Y'all, they're going to ask you that one. I can guarantee it. Y'all, so can the buyer and seller sign a contract of sale without having first completed this document?
No.
Not legally, right? This law says this must be completed prior to entering into a contract of sale. Everybody got that? All right. So if you think about this, if you're representing the buyer, do you think it would be a good idea to get this form, which should already have been filled out by the seller? Should the buyer get a copy of this before they submit their offer?
Yeah.
Yeah, because y'all, let's say you send me an offer on a house I've got listed, and let's say my seller likes the offer. Can we sign it and accept the offer?
Yes.
Not without completing this first. So guess what you should have attached to your offer when you send it to the seller? This form. Y'all, this got to be signed by both the buyers and the sellers. Okay. Now the seller has to fill it out and sign it. Then the buyer has to sign it acknowledging that they know what the seller's saying about the condition of the property. So until I, as the seller, get this back from the buyer, signed by the buyer, can I accept your offer?
No.
No. Now, y'all listen to me. Agent, they do it all day, every day. It's wrong. You're going to get your clients in trouble. If you're the seller, if you're representing the seller, do not let your seller accept the offer until that buyer sends, or that buyer's agent sends you a copy of this form back signed by the buyer. Okay. You know, you're gonna create some legal problems potentially for your clients if you get ahead of, you get too far ahead here. Okay. So just be aware of that. Now, here's another question I would ask. Who is responsible for actually filling out the form? Answering all the questions. Who?
The seller?
The seller. Okay. Now, assuming the seller lists their house for sale with an agent, who is responsible to make sure the buyer gets a copy of this disclosure from the seller?
The agent?
Well, let's look at it. Y'all, if we're still on that page 1.
Yeah.
Y'all, if you drop down, y'all, it's not the last paragraph, but it's the last big paragraph. It starts with if owner is assisted. Y'all see that?
Mm-hmm.
Look at that first line. If the owner is assisted in the sale of the property by a real estate licensee, the owner remains solely responsible for completing, which we just talked about, and delivering this disclosure statement to the purchaser. So who's responsible to fill it out and make sure the buyer gets it?
The seller.
It's the seller's responsibility here. So now, having said all that, then what's the agent's responsibility here?
So basically make sure they have it if they're a good agent, so that we don't get in trouble.
Okay. Well, for the most part, you're responsible to make sure your client, whether it be the buyer or the seller, knows what they're responsible for. You know, if you're the listing the house for sale for that seller, you got to make sure the seller knows, seller, this is a form you have to fill out. This is not an option, not a suggestion. You're required by law. You got to fill this out, and you have to make sure the buyer gets a copy of it and get them to sign it and get a copy back before you can accept any offers. Right? So y'all, your job is to make sure they know that. Y'all, if they get ahead of the game, they start, y'all, if they go ahead and accept the offer and they never got this back because they didn't know any better and you didn't tell them, everybody's got a problem now. Everybody's going to have a problem. So be careful with this one. Now, a couple things I just want to make sure you understand. We already know the seller should fill this form out. Y'all, please hear me here. And this is not for test purposes. I'm trying to keep you out of legal trouble. Do not fill this form out for your seller. Don't do it. Y'all, it doesn't say it on the form, but it does say it in the law, what I'm about to tell you. But the law says whoever fills the form out is now considered the signatory to this document. Now, why they use those terms, I don't know, but here's what that means. If you fill this form out for your seller, y'all, and I'm telling you what a lot of agents will do, they'll simply, y'all, because they just think they're helping the seller. Y'all, that's what we want to help our clients. And they'll start, and we'll look at some of these questions here on the next page and over here in a little bit. But basically, the agent will read the question to them, let the seller tell them the answer, and then they just fill it out for them. Right? It just helping a little bit. Yeah, if you fill this out, that means you're now liable for everything in this document and not in it. You're now liable for it. Look, we got enough liability and responsibility all by without having to worry about this. Let the seller fill it out themselves. Now, is it possible you could have a seller that for physical or handicap reasons, they cannot fill it out themselves? Is that possible? You may have
Yes.
that. My suggestion to you would be, if that's the case, they need to have a family member that'd be willing to do it for them, or a friend or a neighbor or somebody. But guess who is not going to fill this out for them? Me. I'm not doing that. I can't take on that kind of liability. Not going to do it. So y'all let the seller fill it out. Or if somebody, a friend of theirs or a family member wants to do it, that's fine too, but it ain't gonna be me. Now, having said that, now who's responsible to make sure it gets to the buyer? The seller.
Seller.
Now, there's nothing wrong from a legal perspective with you helping the seller get it to the buyer. In fact, you're going to help them do that. Y'all, there's a number of things you can do, or at least what I do. Y'all, once they fill it out, now I always keep the original in my file. I never give the original to anybody. I keep the original they filled out to myself in my file. That way I can make copies of it. And I'll usually make 10 or 15 copies and have a stack of them, and I'll just have them somewhere in the house where as buyers come through, they can pick one up if they want to. But you can also upload this document and any other document for that matter onto the MLS. So any agent going on the MLS searching a property, they can go, they've got a link there you can go to with documents attached, and you can just open up the PDF file, print it out, and they got it right there. So there's nothing wrong with us assisting or helping the seller get it to the buyer. The point is, if for whatever reason they don't get, if the buyer doesn't get it, who's responsible for it? The seller. Everybody okay with that? We clear? We're good? All right. All right, so y'all, if you look over on the next page 2 of the form, y'all, this is where the questions start. Now, we're not going to go through all these questions tonight anyway, y'all, and they're not going to ask you all, you're not going to have to go through all these questions for the exam either. But do you think it'd be a good idea, just from a practical standpoint, to at some point review the questions, see what kind of questions they're asking about? And if you don't understand what they're asking, do you think you might want to find that out before you go hand it to your client to fill out? Because they go, well, what does that mean? I don't understand that. And you ain't gonna look too bright if you can't tell them what that means. So y'all make sure you know what the questions are asking. But what I want to point out to you, y'all, you'll notice to the right of all the questions, you see 3 squares out to the right of all the questions, where they either have to check yes, no, or no representation. Everybody see that? Good. We need to talk about those. Yeah, if the seller marks yes to any question, what do you suppose that means?
They know there's a problem.
There's a problem. If they check no, what do you suppose that means?
They're not
No
aware of the problem.
issues.
And if they check no representation, what do you suppose that means?
Doesn't apply.
Well, I'll tell you, and for whatever reason, I'm starting to see more and more questions check no representation, which is kind of baffling to me, but that's what we're seeing. So what I have learned over my years of real estate, I don't think most people know what that means. They check it thinking they know what it means, but might not. So every time I see a question checked that way, I always call the listing agent and I say, hey, look, I was just going over the property disclosure for that property and question whatever, your seller checked no representation. And I'm just curious and just I want to make sure I'm clear. But what does that mean to your seller? I just want to make sure that we're all on the same sheet of music here. But I will tell you, more times than not, probably 70, if not 80% of the time, they always come back and say, because they don't know. If they don't know, then they can't make any representation one way or the other. They just don't know. Okay, well, let's take look at the very top of that page. You see a square at the top with 3 lines in it? Y'all see that? The question you're answering is on the second line. And here's the question. As owner, do you have any actual knowledge of any problems concerning? And then you just go down. Number 1 is the water supply. Do you have any knowledge of any problems concerning the water supply? Now, if you're going to check no representation and then tell me that means don't know, I probably wouldn't come out and say this outright, but in my mind, I'm thinking, well, then are you a moron? How can you not know if you have knowledge or not? The question doesn't ask you, are there any problems? The question says, do you have any knowledge of any problems concerning, in this case, water supply? So how are you going to tell me you don't know if you have knowledge or not? That makes no sense. Obviously, it does not mean don't know. That's not what it means. But before I get into what it does mean, let me go back and clarify a couple of things. So what does yes mean? If I check yes, you're saying, yes, I have knowledge of a problem. I know there's a problem with or whatever the question's asking. But no, be careful with this one. No does not mean there are no problems. No means I have no knowledge of any problems. Could there be problems with the house and the owner not know about it?
Absolutely.
If you don't believe it, have a home inspector come to your house tomorrow and he'll leave you with 35 pages of problems you had no idea existed. So just be careful. So let me ask you, if the seller gets to a question asking, whatever, and the seller says, well, frankly, I don't know. Okay, well, then what should you answer?
No.
If you don't know, then put no. Again, no just means I don't have any knowledge of a problem. All right, everybody okay with that? So now we get to then what does no representation mean? Basically, if you turn back to the first page, the instructions page, it tells you on here, but that nobody in the world knows what this means. But if you look right in the middle of the page, y'all see the paragraph where there's 2 asterisks there?
Mm-hmm.
It says, if the question is answered no representation for any question, The owner is stating that the owner is making no representation regarding the conditions or characteristics of the property, but owner still may have a duty to disclose information that is known or should have been known. What the heck does that mean? Yo, nobody knows what that means. Yo, that's some attorney wrote that, just trying to make everybody confused. But I finally got the real estate commission to come out and just put it in layman's terms. Just tell me, what does that mean? So basically, if you check no representation, what you're saying is this: yes, there are problems, but I plead the fifth and choose not to discuss it with you. Do you think that's a good answer? You are asking for trouble. In fact, furthermore, I will tell you, and I've got this annotated. Y'all see at the very bottom of the page, the two more asterisks there? Y'all see that? That's important. Now, y'all look where I put those asterisks. This is not actually in the form. This is something I added to the form for class purposes. But the law does say this, and I would remember this if I were you. The law says anyone checking no representation to any question must, y'all, and the law says must, not should, must consult with an attorney to determine any potential liability you may have for checking this answer. Y'all, they could ask you on the exam. If a seller checks no representation in any question, what should they do? Consult
with an attorney.
with an attorney. If you're telling me I'm going to need to consult, if I'm going to need an attorney, if I check that answer, I did not mean to go there. Right? I'll stick with the yes or no. Either I have knowledge or I don't. Go from there. All right. Any questions about that? We're good? All right. Again, y'all, I'm not going to go through all these questions because I know y'all are. But if you turn over to, it's page 4 of the document. Page 4 of the document. And y'all, just something I want to point out to you. Y'all, at the very bottom of page 4, that last paragraph, in fact, you see some lines there, some space where you can write stuff in. Y'all, that's where, y'all, if you check yes to any question, then y'all, obviously you're saying that you have knowledge of a problem. Then you got to disclose what is the problem. And that's where you would do that. You can't just say, yes, there's a problem and not tell me what the problem is. So, y'all, that's another thing they could potentially ask. Y'all, if you check yes to a question, do you have to explain what that problem is? Yes, you do. And that's where you have to put it. Okay. And then over on the next page, which is the page 5 of the form, in fact, this is what I call the signature page. You see right in the middle of that page where the owner or seller has to sign. And then at the bottom of that page is where the purchasers have to sign. And then everybody gets a copy of it. Okay. Now, here's something I want to also, what I'm about to go over right now is not for test purposes, but this is to keep you out of trouble and potentially your client out of trouble. On that signature page, if you look near the top, under the first paragraph, you'll see where they have an option to check several items there. Where it's owner occupied or vacant or short sale. Y'all see those options where you can check whatever applies? Well, one of those options is the house vacant, or the house is vacant, I think. Y'all see that one? I want to talk about that real quick. Y'all, if the owner of that house should move out, in fact, let me say, if you own a house and you decide to move, you move out, whether you rent it to somebody else or you're moving out because you're selling it or whatever. Because I'm telling you, a lot of houses that are for sale, the owner has already bought another house and moved into that house. So this one they're selling is now vacant. Did you know if you move out of your house, that voids your insurance policy? Did y'all know that?
We found out the other night.
Did Joseph tell you that?
Yeah.
What were y'all talking about that for? We wasn't even to that point yet.
No, we were just talking about a situation.
Yeah, because someone's HVAC system was stolen.
Had a
and it was
client that got-
covered
Yeah.
In that
'cause it was
situation.
vacant.
Well, y'all, is it possible somebody call you wanting you to sell their house and then you find that there's vacant, they've already moved out? Yeah, it happens all the time. Y'all, the first thing you need to ask them, have you contacted your insurance company? Y'all, because I'm telling you, when you move out of that house, that voids your insurance. I don't care if you're still making those payments or not. Y'all, as soon as that insurance, y'all, if that house should catch on fire or flood or whatever, and you file a claim, as soon as they find out you don't live there, they're not going to cover those damages. But if you contact the insurance company and tell them that you have moved out, y'all, they'll replace the homeowner's policy with what they call a dwelling policy. Typically, it doesn't even affect your premium. If it goes up at all, it would be very little, but usually doesn't even go up at all. But if you don't tell them that you no longer live there, you're going to void your insurance policy. Y'all, you cannot have a homeowner's policy if the homeowner doesn't live there. Okay? Y'all, I'm telling you, that's a common occurrence. You better make sure your client knows that. Y'all, especially when you got a bunch of people coming in your house to look at it, y'all, you never know what could happen. You better make sure you got insurance. Okay. All right. Y'all, then over on the next page, y'all, you'll see, y'all, this is called the addendum to the property disclosure. Y'all should see that at top, addendum. Now, this form is not required on every house. I'm talking about the addendum now. But this addendum is only required if the house or property is subject to a mandatory homeowners association, an HOA. So if you got an HOA, you have to fill out the addendum. And you'll notice all the, well, I think it's 10, 11 questions there. But the questions they're asking on the addendum is all dealing with HOA. Okay. If there's no HOA, then you do not have to fill out the addendum. Any questions there? We're good? All right. Y'all, the next thing you should see, still talking about this property disclosure statement. Y'all, you see a page of exemptions. In fact, y'all, there are 13 exemptions. So anybody selling their home, y'all, residential property, that meets one of these 13 criteria would be exempt from providing the property disclosure form. They would not have to provide it if they meet any one of these 13. Y'all, you need to read over these. Y'all don't try to memorize them. Ain't nobody gonna ask you to list the 13 exemptions. Y'all, they're not gonna do stuff like that. But you need to have an idea of what kind of things are exempt, right? But I will tell you, there's two questions I hear they like to ask about the exemptions. So I'm going to go ahead and tell you one of them right now. The one question I like to ask is, which of the following exemptions do you think would be the most common exemption? And the answer they're going to be looking for is number 10. Any sale involving a dwelling that has never been lived in or inhabited before. Y'all, they're talking about new homes. Brand new homes are exempt because nobody's ever lived there before. New homes are exempt. So are builders exempt? Yes. Y'all, that is the most common exemption right there, new homes. But the other exemption they like to ask about, and I can about guarantee you they'll ask you this one, is the very last one. Oops. The very last exemption, number 13. If the buyer and the seller agree in writing that the seller does not have to provide this disclosure, then the seller is not required to provide it. The seller, you better have that in writing from the buyer where they've said that they don't require it, and the buyer has the right to exempt the seller. Everybody got that? Yeah, they'll ask you that one, I can about guarantee you. Any questions about those? All right, well then over on the next 2 pages, y'all, what I put there in your book are really excerpts from the property disclosure law. And again, I'm not going to read all that stuff, but a couple of things that a few things I want to point out to you about what the law is saying here. You know, and the first thing is saying, the seller, we already said this, but y'all, you know, the seller has to disclose all known issues, all known defects with the property. The seller has to disclose that. Now, y'all, is it possible? In fact, y'all, let me give you this example. Y'all, and I've had this actually several times. This has happened to me, where I'll be sitting down at the kitchen table with the seller going over all the paperwork we need to get filled out to list the house. And I've had to sell, in fact, not too long ago, I had the seller just come right out and ask or tell me, Frankie, I will just tell you, if it should rain like really, really hard, the roof might leak just a little bit in that far back room. Now, is that something that we should have to disclose to buyers?
Yes.
Absolutely. Well, that's a defect. And I remember telling the seller, I said, well, seller, I appreciate you telling me that, but we got to, now we're going to have to disclose that to buyers. And this seller said, no, I was just telling you that because you're my agent. Don't you start telling buyers my roof's leaking. You tell buyers that, ain't nobody going to buy this house. And now he's telling, Frankie, do not tell anybody. I was only telling you this because you're my agent and you're representing me. Well, can I disclose it if he gave me an order? You remember one of my fiduciary duties is obedience.
Yes, because it's not
But you,
confidential.
yeah.
You have to keep it confidential.
There you go. Y'all, you should see that at the top of the page. Y'all, you can never keep defects confidential. So seller, you can tell me all day long not to disclose it. I'm telling you, number one, you have to disclose it. You got to put that in this property disclosure. But if for some reason, if you don't do it, then I have to disclose it myself. Y'all, the point I want to make here is, y'all, if your seller does not disclose issues and you know about the problem yourself, then do you have to disclose that issue?
Yes.
Oh, yes, absolutely you do. And then I have sellers say, well, what do you mean a defect? What's a defect? I mean, what's a material defect? Well, there it is in the law. Y'all, they list in paragraphs 1 through 7, there's examples of defects. Y'all, I'm not going to go through them all. They're common sense stuff. But here's
One question about that.
Okay.
You said that if the seller doesn't necessarily list that defect, like let's say for instance, if they fill out the form and they know it, but they don't, but you know it. So do we have a different form that we have to fill out in that case to disclose?
Called the MLS.
Oh, so we disclose that in
I just
MLS.
put it in the MLS.
Gotcha.
But
Now,
you're
first
still
off-
uploading that form that they
Yeah,
said that
that's
didn't
what the
have
seller,
any issues.
yep, that's what the seller told me to give them, so that's what I'm gonna give them. But I've told them otherwise. Remember, that was my
Now,
deal.
one more question. Because he talked about us staying in our lanes because we don't really know about roofs and all that stuff.
Okay, well, if you
How
know,
do we
it's
for
leak-
sure know?
well, if you know it's leaking, do you think that's something you should disclose?
Because I see it myself. Or like, would you
Well, I
look
mean,
up and like,
potentially.
say it's a water damage? Because
Well, potentially, well, I tell you what, save that. We're gonna take a break here in a few minutes. But after the break, we're gonna actually get into, I think we'll get into some stuff that's gonna answer that question. Okay? So if you'll hold, that's a good question, and we're gonna talk about that. All right. But there's a couple things I want to knock out before we go to the break. So we talked about what our material defect, or we see in there listed. Y'all, these are common sense stuff. And by the way, what I tell my seller, y'all, occasionally I have a seller say, well, Frankie, what about so-and-so? I mean, is this something that you think I have to disclose? Y'all, because obviously when they ask that, they're thinking it's a little minor thing and it shouldn't be a big deal. Well, my response is always this: seller, if you were the buyer, would you want the seller to tell you about that? And usually, what do you think they're going to say? Well, yeah, probably so. All right, well, then disclose it. Yeah, I've never seen anybody get in trouble for disclosing too much. Yeah, if there's a question whether I should or shouldn't, do it. Disclose it. I'd rather disclose it and not have to, and not disclose it and then get in trouble because I did. All right. Y'all, at the very bottom of that page, y'all, what it's talking about here, you should see where it says failure to provide disclosure statement. Y'all, is it possible the seller just refuses to fill it out and provide it? It's possible. I'm gonna tell you, it won't be my client because I won't list the house if they refuse to do it. But if they refuse to do it, y'all, here's some things that both parties need to understand. Y'all, and this is why I was saying earlier, y'all make sure before we agree to that contract to sale, this is completed. Because if you don't complete it, the law specifies 3 things that will not happen if it's not provided. One, it will not void the agreement. Y'all talking about the contract to sale. So buyer, you can't come back later and say, but you never gave me that property disclosure, so I'm not buying this house. Oh, yes, you are. You signed that contract to sale, you're buying the house. 2, it does not create a defect in title. And 3, it does not create a valid reason to delay or interfere with closing. So in other words, buyer, you go ahead and submit that offer and that seller accepted it and you never got this property disclosure from them, too late. You still got you can't get out of it. Everybody get that? All right. Y'all, over on the next page, you see where it, in bold there, it talks about corrected disclosure statement. Y'all, is it possible the seller could fill the form out and a few weeks later something break, or we got a defect, or there's something wrong, or we now have knowledge of a problem? Could that happen? Yes.
Yes.
Well, do you have to go back and correct the disclosure statement, or can you just say, well, when I filled it out, I did not know about it? No,
I mean, can you put it in the MLS like you were saying, like you had knowledge of it instead of doing a new form?
No, you got to go back and correct the form. The law says if your knowledge or anything changes, you got to go back and correct it, fix it. Yeah, and then the last thing I want to point out is on the very bottom of that page, we're talking about the obligation of the purchaser to inspect. You know, a lot of times you'll have a buyer say, well, do I really need to go pay $400 for a home inspection if the seller has to tell me what's wrong with the house by law? What's the point in paying a home inspector? The law says, buyer, you have an obligation to inspect the property yourself. Because first of all, the seller is not required by law to disclose all the problems with the house. What are they required to disclose? Things they have knowledge.
Yeah, knowledge of.
So you can't just rely just on the property disclosure. The buyer still has an obligation to fill or to have the house inspected and make sure that they're comfortable with what the results are. Okie dokie.